see you. Can't hear you.
Good afternoon, everyone. I see we have the subject of limitation is riveting, and as is evidenced by the number of people we have attending. Historical all-time low for OffshoreAlert.
They're all down there eating ice cream. Seriously, they put out ice cream.
But let's try and have some fun with what can be a very boring subject, limitation. It's actually not boring if you're a claimant or a victim of a fraud and your lawyer tells you, sorry, you're out of time, you have no rights. You've lost your rights through the effluxion of time. So time is an enemy for claims. It is a destroyer of a right of claim. And it deprives claimants from access to justice. Because if you are out of time, you are told to go away in a summary basis, usually at the beginning of the proceeding before you have a chance to have a trial. So today we're going to address the subject of limitation, quote, beware the snake in the grass. And we're going to talk about limitation in the context of our work in fraud, breach of fiduciary duty, corruption, cases where there are some peculiar problems that arise given the setting. And I'll come back to the setting, the fact setting, the context, the theme in a moment. Firstly, just a little intro for Annette. Annette Escobar is with Astigarraga here in Miami, with whom our firm has the pleasure of working on many matters. Annette, why don't you offer a few introductory remarks yourself?
Hi, my name is Annette Escobar. I work with Astigarraga Davis. I'm a partner there. I have been working with the firm for 15 years, and I've been specialized in fraud and asset recovery for some time now, like 5 years, I believe. And just as way of introduction, Martin and Ed Davis are co-general counsel for the Stanford estate, and that is part of what the issues, and I work extensively on the case as well, and that is some of the issues that we're going to discuss in the context of some of the things that will come up with the statute of limitations.
Okay. So where do we start? We start with, well, why are these things called, what are these things called limitation? Why is there a limitation on claims? If someone's been wronged by someone else, why is there any time deadline or period imposed by the law on the institution of legal proceedings to seek a remedy? Well, policymakers say over time the evidence which reveals the truth begins to die, or it's spoiled, or the witnesses lose their memory of what happened in material events, or documents get destroyed. We're going to talk a little bit about investigations in fraud cases and another type of limitation period we face, which is just the destruction of valuable bank records in fraud cases, where we're told when we go to banks with subpoenas frequently, well, thank you for the subpoena in the standard form letter we get. In the state of New York, the New York State Department of Superintendent of Banks advises us that we only need to retain bank records for a limited period of time. I think it's 5 years, it could be 6 in New York. It changes between 5 or 6 years in most places. Some are 3, but if you don't get at the bank records within that period of time, banks will decline to provide them, and then you have a big fight about whether the banks have something called backup systems where the material still exists, it's just in a different place. And that's important because when we're talking about limitation, we use the deadline to institute proceedings. We're also told that certainly in the English system, we're not allowed to start proceedings. We're not allowed to sue someone in serious cases involving serious accusations of fraud, dishonest breach of fiduciary duty, corruption, conspiracy. These are serious accusations. And in English law, a barrister is prohibited professionally from signing a pleading to start a proceeding unless all of the necessary particulars, the specific facts that would support a claim of fraud against someone have been articulated sensibly, credibly in a pleading. Well, how do you do that without facts? Well, you need to have an investigation. And what if bank records are being demolished because of short limitation periods dealing with bank records? So how is a claimant supposed to comply with a deadline called limitation substantively if he's facing other limitations procedurally on just the investigation itself? Ed?
I have a question. I mean, going back to the initial philosophy of why we have statute of limitations, there's always this tension between justice and the need for finality, right? That's the two things that are battling here, I think. Why is it that we can have some legal cultures with no statute of limitations on a murder where the evidence really does die, right? And people, the witnesses die, but in a financial crime where the evidence usually doesn't die, it's many times in documents that aren't going to ever go away, we have these statute of limitations. What is it that, what is the philosophical reason why we would want to have that other than perhaps business needs finality?
Well, a cynic would suggest that defendants typically or frequently are powerful, wealthy institutions and have powerful lobbies in local, state, or provincial legislative assemblies and are quick to want to shorten limitation so that they have commercial certainty and not have to pay out in claims.
Is that legal malpractice is the shortest statute of limitations in the state of Florida?
You could argue that. I know since leaving my homeland of Canada in 1984, I left as a young lawyer. I'm shocked by how legislative assemblies across Canada, provincially, which is under the British North America Act, still the power to define limitation is provincial, not federal, with some limited exception in Canadian law, like I think in the United States. It's a state law affair, limitation. And we have this trend in Canada now where historically in England, and still in the Caribbean, our limitation rule generally is 6 years from the date that a cause of action accrues. We'll come back to what that means in a minute because it's complicated. But basically, from the date when you have a claim, you usually for tort and contract and fraud cases in the Caribbean, English-speaking Caribbean, and in England and Wales, and most of the English Commonwealth, it is 6 years. General rule. In Canada now, we have these 2-year rules that are popping up everywhere on everything. In Alberta, if you come to Alberta, there's a huge case that involved a fraud abroad, torturous litigation. It went on forever. Finally, a major judgment was entered for hundreds of millions of dollars. But it took the investigators a period of time to find assets that were situate in Alberta, consisting of a ranch worth $40 million. They tried to recover the judgment against the ranch and were told, sorry, the Alberta legislator said that you have 2 years from the date of the judgment to seek recognition of it in Alberta, regardless of when you find assets in Alberta. They didn't find them within the 2 years, so it made the recognition proceedings hopeless. So I think the general theme is, when we call it a snake in the grass, it really is, because it changes these rules of limitation which deprive access to justice and access to seek remedy are quixotic. They change from place to place. My thesis is proven by just looking at this. On the action of common law fraud, deceit, which is lying to trick someone for money, in most common law jurisdictions and the following U.S. states, it's 6 years, as I said before, as to the British common law. But also that applies to Hawaii, Indiana, Maine, Michigan, Minnesota, New Jersey, New York, North Dakota, South Dakota, Vermont, and Wisconsin. So 6 years in all those places, fair to play to people. So victims, you got 6 years in those places to sue and deceit, just like in the British Virgin Islands, just like in England. That's the old 6-year rule. However, in a number of places in this country, the period has been shortened, not just in debtor-friendly states. So how is a victim to know, logically, that not just in Delaware, where you might see some spiciness going on against claimants, it's where it's 3 years in fraud, Alabama has shortened it to 2 years. So someone tricks you out of your money in Alabama, you got 2 years to sue. And who would know that? Outside of Alabama, I mean. Statute of limitations for fraud and breach of fiduciary duty in Louisiana is 1 year, 12 months. What a lovely place. Maybe there was some corruption in the legislature. Governor Huey Long or someone? Did someone bribe someone to convince them that in fraud and breach of fiduciary duty cases you have 12 months? Time limit?
Well, we also have to remember that in the case of Louisiana, it's the civil code, which is based on the Napoleonic code, which has shorter statute of limitations. So that might be in part, like in South America, the statute of limitations are considerably shorter. So that might be part of what you're seeing there with respect to Louisiana and the statute of limitations.
Okay, well, but why is it Louisiana fraud is 1 year and breach of fiduciary duty is 10 years? Why is it that in Louisiana, okay, in Rhode Island it's 10 years? So my thesis is it's a snake in the grass because you just don't know what it is, and they change all the time. Like I say, I left Canada in 1984, it was 6 years. I go back to my homeland, it's 2 years. And we're going to come to how serious that 2-year rule is in a case study example we have on the Stanford International Bank versus Toronto Dominion Bank for a paltry $5.5 billion of damages swinging from plaintiff to defendant over a limitation, I would say. You want to start reviewing your material?
Well, just to go over some of the statute of limitations that apply in the United States, two in particular with respect to fraud and fraudulent transfers, conveyances. And I'm going to focus on Florida because every state in the union has its own statutory or common law bases for statute of limitations. So as I'm sure you all know, we have a dual system of federal law and then state law. In few instances, our federal laws contain their own statute of limitations, so it's often a state law issue. And that is the case for fraud and fraudulent transfer. In Florida, we have a 4-year statute of limitation for fraud. Your fraud claim accrues at the time when the last element constituting the cause of action occurs.
What do you mean by accrue? What does that mean?
Accrue occurs when...
But what do you mean by accrue? What is that supposed to mean to a layperson?
That is the date upon which your cause of action comes into existence.
Oh, you got a claim on a certain day.
Yes, you do. Now your statute of limitation begins to run because your claim has accrued.
What creates the claim? What do you have to have? Typical claim.
Well, in the case of fraud, you need a misrepresentation of material fact.
Some reliance.
Reliance.
Some loss flowing from the reliance.
Right, exactly.
Was the reliance reasonable?
Right, so you need, and obviously each claim that you bring, whether fraud, fraudulent transfer, et cetera, has its own elements. So once all the elements have been satisfied and facts exist to...
Satisfied means when something's happened, some injuries happen, somebody's breached a duty, you got a claim. Isn't that accrual?
Exactly.
Yeah. So lawyers have these fancy terms like the date when the cause of action accrued is when your deadline, the limitation period, commences to click along, click, 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 usually, unless sometimes somebody is fraudulently concealing some of these things called facts from the claimant, because that wouldn't be fair, would it, to have a cause of action that exists because there's been a breach of duty and a loss occasioned flowing from the breach, but the victim doesn't know he's been harmed yet. So how are you supposed to start the clock then, right?
Right, and in Florida, I mean, in many U.S. states, really, when it comes to when it comes to fraud, we have what's called the discovery rule, which allows a cause of action to not accrue, i.e., the statute of limitations doesn't even begin to run until the plaintiff discovers, or with reasonable diligence, should have discovered that they suffered this injury due to a fraud of another. And that is a significant leeway given because by nature fraud is committed in secret. I mean, most people, they don't do fraud until you, hey, you know, I've defrauded you, now come over here and sue me, or you've suffered a loss. So
you got this rule of fairness that if some defendant's concealing elements of the claim from the victim, then the time clock doesn't begin in the United States, generally speaking. Isn't that true?
That is another doctrine, which is called equitable tolling, yes, which is in the context in which a defendant is taking affirmative acts to conceal the facts that would give rise to you knowing that you have a claim or that you could discover that you have a claim, then also your claim does not accrue due to those affirmative acts.
Now let's switch over to, let's go back in the mists of time.
One thing I would like just to add is that in most jurisdictions...
I like the mists of time more than adding, though. What do you think, Annette?
One tiny point.
Okay.
In most jurisdictions in the United States, there's also a statute of repose. So for example, in Florida on a fraud claim, no matter when you discover it, you can't bring it more than 12 years after the fraud occurred. And that it goes back to the policy reasons that they were discussing before of finality, and you don't want this hanging over your head for the rest of your life. I mean, if you take somebody's body, it's probably a little bit more serious.
So an area of fraud is called the law of fraudulent conveyance. When someone has property or assets and gives them away to someone else for ostensibly sometimes nefarious purposes, to defeat an obligation, to deprive a claimant from access to justice by squirreling away the very fruits of the wrongdoing complained of by plaintiff. Could be a fraud case or a bank who loans money to someone and the debtor decides not to repay but rather gift the property into a trust for his children or himself. This is a problem that has been around for a while, and in the mists of time, during Tudor England, Queen Elizabeth I's reign, the brilliant monarch, 1571, Parliament passes something called the Statute of Queen Elizabeth I. And this, the purpose of the law was to prevent assets from being squirreled away by debtors by gift or for nothing in exchange or something unreasonable in exchange. And the statute declared these conveyances that sought to delay or hinder or defraud creditors as being, quote, utterly void. That had a big consequence in this area of limitation. Why? There was no limitation period, nothing within which an action had to be brought, no time period, because conveyances that were deemed fraudulent under the Statute of Queen Elizabeth I were deemed void, not voidable. They were done. They didn't exist as a matter of law. Now we have some other things that happen. Equity and Chancery came along and said, well, we've got a thing called laches or latches, some people call it, that says, well, witnesses forget things and documents are destroyed, so the Chancellor... No, latches.
Some of us say latches, you know.
And in any event, so this was something powerful for creditors, and it's the Statute of Queen Elizabeth I you find all over the English-speaking world in some form in modern legislation, the magic words to delay, to hinder, defraud. However, in modern-day approaches to the enactment of this ancient Tudor statute, we've bolted on limitation. In the United States, you've got the 4 years, you've got sometimes 6 months, you've got different periods. Why don't you summarize those?
See, certainly in the United States, we have the Uniform Fraudulent Transfer Act, which has been adopted by 43 jurisdictions and the District of Columbia, including Florida. Some others, like New York, have the Fraudulent Conveyance Act, which is similar in many respects in application, but it has different statutory provisions. So it's you have to look at each state again. Should you go to pursue a claim for fraudulent transfers, but there's lots of similarities. And in Florida, for example, you have a 4-year statute of limitations, plus you have a 1-year discovery rule if in the case of a fraudulent transfer made with the intent to delay, hinder, defraud the creditor. In New York, you have 6 years to bring the claim as a statute of limitations, and then you have 2 additional years from the time that you should have or could have discovered the claim with reasonable diligence. In Delaware, you have 4 years, just like in Florida, and you have the 1 year. So shockingly, actually, Delaware is not overly restrictive on the point of the statute of limitations on fraudulent conveyance claims. There's some special rules in some jurisdictions as to the other types of fraudulent transfer claims, but for present purposes, because we're focusing really on the fraud, that pretty much covers the fraudulent transfer statutory issues. There's also, of course, in bankruptcy, in our bankruptcy code, we also have claims for fraudulent transfer and fraudulent avoidance. In the context of the bankruptcy case, causes of action that you might bring in an adversary proceeding, for example, the statute of limitations, in addition to what might have existed before, is the latter of 2 years after the entry of the order for relief, i.e. when you get your order granting relief in bankruptcy, or 1 year after the appointment of a trustee, if that time ends before the time of 2 years from the filing of the bankruptcy. So in theory, you could have almost 3 years based on that one provision. And some of you might have recalled from Greg's presentation earlier on the bankruptcy code as well, that there's a safe harbor in the context of securities litigation, which he explained as to the UFTA claims brought in the bankruptcy code in that context. And of course, if the case is closed, if the bankruptcy case is closed, you can no longer bring the claim. I mean, that's pretty obvious. But the statute does expressly state that if the case is closed, then your statute of limitations has run. So as far as fraudulent transfer, those are the main points on without applying common law concepts to extending the tolling periods.
So now let's take away from relatively civilized United States and go to other places that have made different policy choices. So starting at about 1985, there was a lawyer in Denver called Ron Rudman and another lawyer called Barry Engel, and they produced a product called Offshore Asset Protection Trust legislation. And they helped to, with some other asset protection lawyers in the United States, promote a product that was adopted in many places offshore, like Belize, the Cook Islands, Cyprus, the Bahamas, Nevis. These places wanted to enter into the offshore financial sector. They were behind Bermuda, which had cachet with very substantial, legitimate family trusts that had been established in Bermuda for decades. And but they thought, well, why don't we get a competitive advantage by making this a very friendly place for wealthy people that, well, may want to not repay obligations they may owe to a wife, a bank, or in the case of fraudster victims. So let's enter the competition to sell offshore asset protection services by playing games with limitation. And what I mean by, and other things that they do to make it attractive to people wanting to avoid obligations and to deprive people of access to justice, with creating a platform where it makes it very hard to bring claims. In Belize, you have, for instance, Section 37.2 of the Belizean LLC Act bars any creditor from bringing a fraudulent transfer claim against a Belizean LLC, where the claim is brought after the earlier of two dates, 2 years from the date of the transfer or the gift to a Belizean LLC, or 1 year from the date that the LLC was formed. So it's the earlier. I mean, someone has a bad sense of humor when they make a policy choice, draft up a bill, go to this little jurisdiction with 300,000 people and persuade legislators to embarrass themselves with such a statute. I mean, that's just silly. Yes?
Does this affect enforcement of judgment? So if you get a judgment here or in Canada, can you enforce that judgment in Belize?
Oh, there's another clause that says no. Only judgments issued by a Belizean court are enforceable against a Belizean LLC, but that's a different provision.
You can't domesticate a foreign judgment in Belize.
not against a Belizean LLC, because Section 38(1) says you're not allowed to bring any foreign judgment there against a Belizean LLC. It has to be only a judgment from a Belizean court. Again, a fantastically interesting policy choice. Now, the Cook Islands, it's a nice place in the South Pacific. They entered the competition, and they've got lots of spicy provisions too. All of these places, by the way, they shift the burden of proof from the civil standard of proof beyond a balance of probabilities, which means perhaps 51%, 49% probabilities in terms of what the truth may or may not be in a case, as to someone's intention to defraud a creditor or a wife or whoever may, a victim. The statutes generally require you to prove beyond a criminal burden of proof, beyond a reasonable doubt that someone sought to defraud someone else. So the normal badges of fraud, objective badges of fraud, giving money to a daughter or a son or trust to benefit yourself, those are not to enter into the debate. You have to show specific intention to defraud a specific creditor. And some of the statutes say it has to be a real and present creditor. In other words, a debt that's liquidated, that's quantified objectively, like a promissory note or bill of exchange, and that has matured, that has become due and payable. So ergo, you're a fraudster's victim. You don't have a debt instrument. There's no promissory note. You got to sue the fraudster somewhere in the world, get a judgment, and then maybe you've got a crystallized obligation that would allow you to bring a claim against some of these trusts. So if you don't bring a claim within the shortened period and have a liquidated claim to do so, you're out of luck as well. Bahamas, Cyprus, and Nevis have the same type of rules, which provide for these shortened limitations of 2 years from the date of the creditor's cause of action, and Cyprus does as well. Now, how do we deal with these problem statutes? Well, we say there are two ways of attacking them, in my view. One is we need to look critically at what property is, what we're talking about, property being put into a trust, offshore or on. We need to look critically at who owns the property being gifted. Because I maintain, and have been successful in arguing in different settings, that if the so-called, the lawyers use the phrase settlor, which is just the person purporting to own wealth and gifting it to a trustee for the protection features that the trust structure or construct provides to the family or to the settlor and the beneficiaries of the trust. So the settlor's goal in life is to take property that he has earned genuinely and honestly, hopefully, pass it over by gift to a trustee for the benefit of the designated beneficiaries of the trust. Fair play to him. And if he did honestly earn that wealth, I say these statutes actually are effective, and it's very, very hard to defeat some of these limitations if for some reason a claim arises later on and that it was a genuine gift by an honest man. But if you change those facts into, say, an agent, I always like the law of agency because it applies to everything from the bookkeeper in your little construction business who does embezzlement on the principal of the construction company. That's an agent. And she's not supposed to do embezzlement. And she's not supposed to go to Cook Islands and set up a trust and gift the proceeds of the embezzlement to the trustee. And I say on those facts, she is a trustee. The moment she takes the principal's money, a constructive trustee, recognized by equity because the beneficial title never passed to her. The beneficial title to the property that she stole still resides in the construction company, her principal, because she didn't earn it, she stole it. Worse, she, in secrecy, committed a dishonest breach of trust. Let me tell you how seriously English law views that act. It's the only provision in the Limitation Act 1980 of England and Wales that says that, very explicitly, in cases of dishonest breach of trust, there shall be no limitation. It is one of the few private obligations that you get to carry to your grave. Now, case law has said that a director of a company is, for purposes of the Limitation Act provision I'm describing, deemed to be a trustee, and the company the beneficiary. Why? Because for purposes of limitation law in England, the company's property is trust property. There is already a trust. You can't open a Cook Islands trust by busting open an onshore trust held in favor of a company if you're a director or agent or fiduciary of that company. So English law takes very seriously the idea of a breakdown of the duty of loyalty by agents, so much so we take the opposite rule and say there shall be no limitation. So ergo, I say you run offshore to Cook Islands. When you stuff the money you stole from your principal into the trust, you didn't own the beneficial title. So that means, in property law terms, if you just examine the title to the thing of value, a trustee never took the beneficial title because the giver of the title didn't have it to start with. Now, and you get some arguments, well, the recipient trustee was innocent. He didn't know that the embezzling employee of the construction company stole principal's money. So maybe, and the solution is that the trustee should be entitled to take the value. But the problem there is it's a gift, and there was no value given in exchange. So we would say we can attack these gifts by arguing about the property rights of the person who gave it. Now we switch over to Cyprus. I'm working with Annette on a case now on the preliminary stages where we have a Cyprus trust. Assume, in this case, it's a husband and a wife case, and they were married in a place that says that the wife has 50% vested property right in all of the property of the marriage throughout the currency of the life of the marriage. California, which is an old Spanish law system for family law purposes from old Mexico, Arizona, New Mexico, I believe, have these community property state legal systems in favor of wives. Switzerland does, Russia does. This is all over the civil law world in parts. And in this case, it's clear the wife had a vested property right. It's also clear that when they started the marriage, neither spouse had any money. It's also clear that the husband accumulated, let's just, my hypothetical, $10 billion of value. And the wife is ostensibly worth $5 billion of value. The husband doesn't want to pay anything, zero. So the husband flies to Cyprus and he puts into a trust a lot of value, let's say $5 billion. And let's say we know where the $5 billion of value might reside. We would like to freeze it and attach it and recover it for the wife. Because $5 billion, by my reckoning on that hypothetical, is 50% of the value. So we look at the Cyprus statute and it says, first problem, the gift happened of this value in 2008. By my reckoning, it's now 2015. I think we're a bit late, Annette, to attack that trust. If you just look at the trust statute in a linear sense, but if you look at it in a property law sense, we say, well, wait a minute, there's a vested property right, 50%, so at least half the value that went into that trust, I would say, never went into the trust, other than notionally, but the beneficial title, again, didn't pass. However, there's another provision in Cyprus that says it doesn't matter what you say about foreign law property rights, we're going to cut them off. We're going to say that only the Cypriot court gets to decide what happens to the trust property in Cyprus. And we're going to say that after the 2 years, it doesn't matter what vested property right you had or didn't have. It no longer exists from the moment of this strange gift. How do you make a gift when you don't own 100%? You only own 50% when you're a husband trying to hide money from the wife, right? Well, guess what we found? In 2006, we discovered that the people of Cyprus amended their constitution and decided that any national law would be subject to the provisions of something called the European Convention of Human Rights. And, well, because Cyprus is a part of the European Union, and there's this thing called the Convention of Human Rights, and it says in there that a property right that's vested cannot by national law be taken without just compensation, either by private means or public means. It cannot be taken. So if you pass this asset protection statute to help husbands commit fraud on wives. According to the European Convention of Human Rights, this is not a legal possibility. So we think they're going to have a little collision with the Constitution of Cyprus and this convention dealing with this legislation. You know, Nevis has a constitution now too and has similar provisions. And I look forward to the day we can go to the Privy Council with the collision between the human rights rules in the Constitution in Nevis and these spicy little pro-fraudster statutes designed to allow fraudsters to put money into trusts and just say, well, I came to Nevis, I bought citizenship for $400,000, I live here in a condo, and I've got $50 million locked in a trust, goodbye to you. I think they may lose, actually, that debate if we got it to the Privy Council. What do you think, Annette?
I think it's a possibility. Certainly, U.S. courts have not taken a very favorable outlook on debtors trying to pull this off in U.S. courts. And in Florida, one debtor spent 6 years in prison because he would not dissolve his Cook Islands trust. And
For civil contempt?
For civil contempt. And there must be some lawyer out there in Florida giving advice to create Cook Island trusts, because if you search for these sort of cases, there's more in Florida than anywhere else in the country, although there are cases in other parts of the country. And what the courts say, what happens is that the courts, the defendant says, well, I can't, impossibility to satisfy this judgment because I have this Cook Island trust, but it's irrevocable. It's in the hands of the trustee. Then there's like this duress clause in the contract with the trustee that if I tell him to release the funds under duress, then he won't release the funds. So really, there's nothing I can do. I'm stuck. The funds, I can't. There's nothing I can do.
Go ahead.
And then the court says, well, you created that situation, so now you're going to have to undo that situation. And that's how the guy in Florida stayed in jail for 6 years because he didn't pay the judgment that was entered by the SEC against him. And there's, as I said, there's several courts throughout the United States where that has happened time and again.
I think because in the U.S., isn't it true that after a period of time, 6 or 7 years, the judge loses the power to keep him in prison for civil contempt because it becomes penal instead of coercive?
Well, it's supposed to be, that's exactly right. And when the 11th Circuit affirmed the district court, they said, look, this guy isn't paying. We agree with you that he has to pay, that he has not proven any defense to payment, but you can't keep him in there forever. So see how you're going to figure this out. Apparently, they figured it out how to get the money out of the Cook Islands, but
Well,
6 years is a long time.
This is an interesting solution that some bright New York lawyer brought in a case called Whites and Whites in the year 2012, when the New York Supreme Court was confronted with these facts. A divorce proceeding, ex-wife seeks to set aside a number of gifts to a Cook Islands trust. Well, what is she doing in New York dealing with a Cook Islands trust, you might ask? Well, apparently the Cook Islands Trust Company was called Southpac, and Southpac has correspondent bank accounts in New York, and there was questions of whether the trustee Southpac transacted sufficiently in New York by receiving the funds that were the subject of the gifts to the trust. Yes, that's where the husband paid the money in. So he paid the money into the Cook Islands Trust, their correspondent account in New York, because nobody bothered to look at the detail when they're setting up the fancy trust that they're actually paying the money into a New York bank account. And that gave the courts sufficient personal jurisdiction over the Cook Islands trustee, and guess what? The remedy was obtained. Now, there's a more recent case, though. I think this case gives some New York creditors' rights lawyers some headaches. I don't think it would damage that authority, though. It's just called Gilcad and Bank of Hapolim. This is a case in New York where the Supreme Court of the state held that parties could not reach the assets held in the foreign banks branches because they lacked jurisdiction. So that's a different set of facts, where the court found that under New York law, the separate entity rule, where each branch of a bank, where you have a branch in Beijing and a branch in New York, right? Two different branches. Mm-hmm. So if you're a creditor, say, of this bank in China, you can't necessarily attack its New York local branch unless there was some minimum context in the case that you're involved in with that branch. I think that's what that case says. Whereas a bunch of New York lawyers I know were trying to break down the single entity rule to attack recalcitrant debtors' accounts around the world by attacking the branches in New York, and that's now been shut down, I think, right?
Right. I mean, what they were trying to do clearly, I think, is that in the United States, we don't recognize Mariva injunctions, so you can't get a worldwide injunction. So they were trying to serve a bank in the United States, and through them get like all of, Merrill Lynch worldwide or whatever it may be. So in effect, they were trying to get the Mariva injunction that they can't get by law. That would be my interpretation.
So to bring this discussion about these very interesting cases about what very interesting lawyers are doing in New York back to limitation, I call it arbitraging litigation, where you're facing a problem, you're told, okay, Nevis, 2 years, you're out. You're told Cook Islands, 2 years, you're out. So what you have to do for the creditor's side or the victim's side is to look critically at where can we arbitrage the rights of the claimant into a legal system that is more friendly, and it still will provide a meaningful remedy. And that's the whole point of looking. Don't just get stuck in limitation as if, oh, well, I'm done. I've got to tell the client that he's done. There are no solutions at all. That's not true. If you look really carefully at these statutes, like I talked about property rights, vested property rights going into these trusts, or what you can do in New York with some payment systems where, I don't know if you know this, all US dollars are settled electronic. If they're electronic payments, they're settled by money center banks in New York every night in bulk. And those records are sitting in New York on computer service systems at those banks. And you can serve what the IRS people were talking this morning, they call them John Doe subpoenas. I think we do a little more specific ones. We have actual lists of fraudsters and their related companies. We get a subpoena from the U.S. District Court. We serve it on the 5 or 6 money center banks, and we get all this data in spreadsheets showing historical going back 6, 8, or 10 years. I want one case 15 years of wire transfer activity. So if you've got a fraudster in Karachi, Pakistan, who is transferring U.S. dollars electronically to a colleague co-conspirator in Moscow in U.S. dollars, there's actually data in New York that you can gather under this technique, getting these subpoenas served on the New York benches. And again, arbitrage the legal systems to find a solution, both in terms of discovery, if you have problems with bank records, and also with causes of action. I think we should probably segue into the case study example about the discovery principle in limitation, which is a critical idea. In many of the world's legal systems on limitation...
Just one thing I wanted to add, that a creative possibility, at least in Florida, that may exist in order to extend your limitation period monumentally, is we have something called the supplementary proceeding in Florida, which allows you to file claims against third parties who may have received funds from a debtor and implead them into the action and proceed against them in that way. Fraudulent transfer actions are one of the actions brought in these proceedings supplementary against these third parties. If you have a foreign judgment, you can get your judgment domesticated in Florida. We have a foreign out-of-country money judgment act recognition. So you can do it even through the clerk. And at that point, once you file the proceeding supplementary, which I checked, and they do apply to these same foreign judgments, you get 20 years. Your judgment now has 20 years validity in Florida. So certainly that would give you a long time to try to proceed against third parties if you know that's where the funds are at.
Unless the assets move to Alberta and you've got 2 years. Moving now to this case called Stanford Bank. When you enter into a fraud investigation of some significance or complexity, it can take some considerable time for victims or their representatives to understand what happened, let alone identify claims and mount claims. Stanford Bank is an example. It's a case involving 22,000 victims who lost $5.5 billion US dollars of net cash-on-cash capital losses. They are amongst a larger population that paid money into Stanford Bank from 1992 to 2009. Total money gone in the bank, $10 billion US dollars. Interestingly, with limited exception, all that money almost 10 billion, went into a correspondent bank account, which is just a bank account, in the name of Stanford International Bank at the Toronto Dominion Bank in my home country of Canada, in Toronto, Ontario. And unfortunately, we would say that the bank didn't look very critically at what was going on and allowed $4.5 billion to get paid out in Ponzi payments to the older victims. So older depositors got paid off with new depositors' money, classic Ponzi, and that fueled the Ponzi and kept her going for 18 years. Now, in 2009, this fraud was discovered. The SEC appoints a receiver in Dallas, and the regulator of banks in Antigua appoints some liquidators. Now, they're not with all the records. The records of this case are fragmented. There's now a warehouse somewhere in Houston. You've been to that warehouse, Annette. How big is the warehouse?
The warehouse, it's maybe twice this room and then 2 stories. And it's full of stacks and stacks of boxes that are 4 stories high. So needless to say, it would be absolutely impossible to review every document in there.
Well, that's why we have something called Recomind in theory. So scan all this material in, and with some so-called artificial intelligence, we get these data miner, young, bright lawyers that ask a bunch of questions, and they seem to kick out some records. But, you know, when chaos erupts, when you get liquidators get appointed, there were, I think, 200 angry depositors that show up screaming for their money, newspapers, television reporting, $300 million potentially spinning of cash around the world. They had to freeze that. They had no money because the fraudster left no money in the till. There was no cash to fund any investigation. And eventually, though, time passes, and those liquidators had to be removed because they themselves had made some bad judgment and bad conduct and had been excoriated by a Quebec judge for a manifest proclivity for illegality. So then new liquidators got appointed, and your firm, Annette, and my firm got to work on the case. And we started looking at the facts and discovered, looks like a claim against TD Bank for on the continuum of responsibility between stupidity, lawyers call it negligence, to recklessness. You know, when you get in a car and you're drunk and you kill someone, that's called recklessness. When you're driving around a bank and you're allowing $10 billion of proceeds to come in, it's very much like a drunk driving a car, you could argue, depending on the facts. And that's what we think. We think we have a reasonable case to bring. The problem is limitation. In Ontario, it's 2 years. In Antigua, it's 6 years. In Quebec, it's 3 years. These were the jurisdictions we looked at bringing the claim. It wasn't sensible to bring Antigua because the bank's not in Antigua. There's no bank in Antigua called Toronto Dominion Bank, so it'd be useless to bring it there. So we brought the claim in Quebec and in Ontario in case we lost on venue, because we knew that the bank would want to defend the proceedings in Ontario with has a nice little 2-year limitation period instead of 3. So the bank were successful in moving us to Ontario. Now we're facing a 2-year limitation period. But how does that work? In Ontario, you get 2 years from the date when the cause of action accrued. When does it accrue? When does it happen? From the date when under Canadian case law, when the liquidator, when a reasonable liquidator, when charged with the facts and circumstances and having no money and having to do other important imperative things, would have the opportunity to reasonably discover the wrongful acts or omissions of TD Bank, right? So as it happens, we put the claim in 2 years and 3 months after what TD Bank says is the deadline. We say it's on time. They say it's out of time. The whole case falls into what happened the first 3 months of the appointment of the original liquidators. And fortunately, we don't need to examine what they did or didn't do. We just have to look at what the objective facts were and what a reasonable liquidator would have done under those circumstances, or could have done, with no documents, no money, and having 500 other things to do, other than to speculate on developing tort claims against third-party banks in foreign countries. So we think we may have a good shot at getting over the 3-month rule, but it's amazing to me that a case may not be tried that is a case to answer, minimally. It's a case that the bank should answer, the case that should be tried. If a court decides, well, I don't agree with you fellas. I think a reasonable liquidator could have discovered this case within the first 3 months of being appointed. And there goes the opportunity to recover the losses for all the victims in Stanford just because of limitation. It's a very poignant example of how money can move from one side to the other potentially by these technical, boring rules that are just applied in a very rigorous way. But we will see. I think the hearing will be this summer, and we'll see next fall. Maybe next year we'll be able to report to you what happened to the limitation in a $5.5 billion stupidity case against a bank. I think it's now, okay, we've got about 7 minutes or so left. Firstly, do you have any more material you want to cover?
No, I think that since, we're the last of the day, we should probably make sure that we finish on time.
That's right. I think just one note on fee, they're called flee clauses in these trusts we talked about. As some of you may know, and if some of you don't know, these offshore asset protection trusts include provisions that allow a protector of the trust when there's an emergency. Literally, the trustee says, when there's an emergency, the protector's job is to protect the trust by fleeing the jurisdiction of domicile. And if you can believe it, in the Bahamas, Belize, and the Cook Islands trust statutes, both inward and outward migration on an emergency basis is allowed without limitation. Section 1365 of the Cook Islands International Trust Act of 1984 provides that the original trust settlement date governs such redomiciled trusts moved in an emergency for purposes of the statute of limitations. You might ask, what's an emergency in an offshore asset protection trust deed? Well, an emergency is...
in the US?
No, it's not an emergency. Its emergency is when any claim has been brought or threatened by any creditor, claimant, wife, victim, anyone, as much as breathes the idea of a claim is an emergency, and you can flee the jurisdiction and drag along the fact that the 2-year limitation period has already begun to run or has run when you flee to the next place. It's a wonderful little provision. It shows you how aggressive the policymakers are in some offshore jurisdictions, I think in a way that's quite embarrassing, but what can I say?
Where does it flee to?
Oh, it flees
Another
to another one of these places. So each of these places have inward and outward gates. So the statute actually says in the Bahamas, in Belize, and the Cook Islands, we will take inward trusts when they flee on emergency clause basis, and you get to the benefit of the limitation periods that we're clicking along in the Bahamas. So the Cook Islands will take the redomiciled trust, and now overnight it becomes a Cook Islands trust.
Like a criminal safe house.
Yes, and then it...
Just many islands.
Are there direct flights between each of these?
These are notional flees. These are notional acts. They're done by electronic message. Instantaneously you flee.
I hereby flee.
That's
I hereby
right.
accept your flee.
Are there any other questions about limitation? Or yes?
Do you have any idea of the statutes of limitation for the IRS when investigating their U.S. citizens from information received by whistleblowers?
I'm not a tax expert, but I do know that our limitations, when you file a tax return in the United States, there's a period of time that the government has to audit the return. But I believe that the limitations for fraud are pretty wide open, and I think they have the concealment rule. So if the taxpayer is concealing fraudulent acts, I don't think limitation runs. Just like in regular claims for private litigation, it's the same story in most places.
And it's different if you file the tax return than if you never file a tax return.
And how is it different?
Filing the tax return, the limitations period is different than if you never file a tax return.
Well, you have to file a return to start the statute.
Right. So if
Okay.
you never file a return, there may never be a
always open.
statute.
You may never have a limitation.
Correct.
Well, it is the IRS, that they like to get paid.
Okay, any other questions?
A 2-year and a 6-year
3
special
years, 3
limitation?
year and 6 year if you file a
3
return.
years or 6 years, yeah. Which
Yeah.
cases?
3 years is a general limitation, and 6 years if you've grossly understated income, which is 25%, it goes to 6.
What if you
That's
intentionally?
gross.
But it's fraudulent.
What if you just misstated a little bit?
Right, and if you don't file a return, it's open forever.
Right.
Okay. Well, that's very good to know. And I'm glad to say that I don't have to file one of these returns because I live in the BVI.
Many of us unfortunately do.
And I live in Cayman.
Very good. Any other questions?
No, but I'm jealous.
Well,
Announce the title.
Me too, Julie, me too.
okay, well, it's now almost 5:30. The cocktail party begins by the beach that Ed and Annette's firm and apparently my firm are co-sponsoring. So we would invite everyone to have cocktails on Ed's firm and mine right now. And we hope that you enjoyed this riveting discussion of a most boring topic ever, limitation. But thank you very much indeed.